Every year, foreign companies in Vietnam lose major sums in unpaid invoices. And it's not always because the debtor is impossible. Many losses come from preventable legal mistakes, weak contracts, missing evidence, late escalation, or choosing a dispute forum that can't realistically enforce against assets in Vietnam. In this video, we'll cover the most common pitfalls and the practical moves that protect leverage and improve recovery. Mistake number 1 is relying on verbal assurances. We'll pay next month. The director approved. Just give us 2 more weeks. In Vietnam, collection is won with an evidence file, not with conversations. Strong claims are supported by clear scope, payment milestones, delivery or acceptance records, invoices, debt confirmation minutes, bank transfers, and documented change orders. We often see cases weaken because the business performed, but the paperwork didn't. Strong documentation should be built while the relationship is still cooperative, not after the debt becomes overdue. Mistake number 2 is using contracts that look strong internationally but don't work smoothly in Vietnam procedures. If your contract is English only, you may still need a Vietnamese version or a reliable Vietnamese translation for submissions and enforcement processes. The risk is not English, it's inaccurate translation and inconsistent wording, especially around payment triggers, acceptance, late payment interest, termination rights, and dispute resolution. A single poorly translated sentence can change obligations. Well-managed companies use bilingual structures where appropriate, with a clear language clause and legally consistent Vietnamese text. Mistake number 3 is sending soft reminders for too long. Many creditors stay friendly and hope the relationship will unlock payment. But in practice, many debtors move only when they see structure and consequences. A professional demand letter in Vietnamese, confirming the amount due, setting a firm deadline, and outlining next steps, often changes the negotiation dynamic. The goal is not aggression. The goal is clarity, timeline discipline, and a credible escalation path. Mistake number 4 is waiting too long. Evidence gets weaker, key people change, companies restructure, assets become harder to trace or reach. Vietnam also has statute of limitations rules that often apply around 3 years, depending on the dispute type and when you knew, or should have known, your rights were infringed. The legal details can be technical, but the commercial conclusion is simple: delay reduces options. Early action protects evidence, preserves leverage, and increases recovery probability. Mistake number 5 is choosing a safe foreign forum, then discovering enforcement must happen in Vietnam anyway. If the debtor's assets are in Vietnam, foreign judgments or awards may still require recognition and enforcement steps in Vietnam, adding time, cost, and procedural friction. This doesn't mean foreign arbitration is always wrong. It means the dispute forum should match the asset location and your enforcement plan. Smart drafting is not about preference, it's about real-world collectability. Mistake number 6 is skipping debtor profiling before signing. Some losses are predictable: undercapitalized partners, overloaded liabilities, thin legal vehicles, or repeat defaulters. Better outcomes usually start before the deal. Check legal status, representation authority, operational footprint, and basic risk indicators. When risk is higher, companies negotiate stronger protections, deposits, staged payments, bank guarantees, or retention money where feasible. In debt collection, leverage is often created at the signing stage. Mistake number 7 is hoping polite settlement will happen automatically. Commercial disputes can involve delay tactics and avoidance. Without deadlines and escalation, requests may be ignored indefinitely. What tends to work is a structured roadmap, timeline, complete evidence pack, and filing readiness. In certain situations, where legally justified, creditors may consider interim urgent measures, such as preventing asset dissipation, subject to legal conditions and often a security deposit. Settlement works better when the debtor believes you are prepared to proceed. A foreign trading business faced non-payment and kept sending reminders for over a year. By the time legal action began, operations had effectively shut down and reachable assets were limited. Even with a favorable outcome, recovery fell far below expectations, because timing and leverage were already lost. Details adjusted to protect confidentiality. The lesson is simple: winning a case is not the same as collecting money. If your company operates in Vietnam, the best debt collection strategy starts before the invoice is overdue. LTS law can support you with contract audits, enforceability upgrades, evidence preparation, demand letters in Vietnamese, negotiation strategy, and, when needed, arbitration or court action aligned with Vietnam enforcement realities. Visit lts.com.vn. In Vietnam, legal awareness isn't optional, it's your commercial edge.